All right, good afternoon, everyone. It is the top of the hour. We're going to go ahead and start. My name is Sasha Beatty, and I am Senior Counsel at the Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., serving prosecutors as well as their law enforcement and community partners. Thank you for joining this capital litigation webinar today. This project is supported by grant number 15 PPJ A-22-GK-03018-CAPL, awarded by the Bureau of Justice Assistance through the Office of Justice Programs. APA is very appreciative of their financial assistance and commitment to improving the justice system. Points of view or opinions in this presentation are those of the presenters and do not necessarily represent the official position or policies of the US DOJ or the APA. So just some quick housekeeping before we do introductions. If you have a question for the presenter, please use the Q&A widget, which is typically found at the bottom of your screen. We will generally hold the questions until the end of the presentation, and then at that time, our presenters will address them. If you are, in the meantime, having any technical difficulties or questions, such as audio or video issues, please pop into the chat box, which is also typically found at the bottom of your screen, and let us know, and one of us will assist you with any sound or quality issues you might be encountering. Today, our speakers will be sharing some useful tools for you, which you will find in the chat box momentarily. These are 3 checklists that you can use at different stages of the case, and those can be downloaded, like I mentioned, a few moments from now in the chat box, and they will also be shared afterwards on APA's Capital Litigation Resource page. Finally, after the webinar, you will be asked to complete a 1-minute post-webinar survey so that we can continue to provide you with relevant and timely training and technical assistance for your offices. So please provide us that feedback. It really helps us tremendously. Now with that, it is my pleasure to welcome our presenters from the Arizona Crime Victim Rights Law Group today. Randy U. Delman, a prosecuting attorney for over 30 years, has been a past recipient of the Arizona Attorney General's Office Distinguished Service Award and is currently a member of the Arizona Supreme Court Commission on Victims in the Courts. Randall's private practice consists of insurance and commercial disputes, and as a victim rights attorney with Arizona Crime Victims, he helps victims assert their rights throughout the criminal justice system, from indictment through post-conviction efforts to collect restitution. As a part of his victim practice, Randy regularly advocates for changes in Arizona law for the benefit of crime victims and often provides direct victim or amicus support for various victim-centric issues on appeal. Dan Levy serves as a victim advocate and executive director for the Arizona Crime Victim Rights Law Group. Dan has previously served as the executive director of the National Organization of Parents of Murdered Children, Incorporated. Levy previously served as the Office of Victim Services Director at the Office of Arizona Attorney General and as the advisor for victims to Arizona Governor Janet Napolitano. Levy has been a dedicated advocate for victims' rights since 1996, when his brother Howard was murdered. Levy's focus has been to change and improve public policy concerning the treatment of crime victims and their families, and he has been involved in crafting numerous pieces of victims' rights legislation. So thank you both so much today, and I will be turning it over to you.
Thank you, Sasha. We'll get the presentation up here.
And I also would like to say thank you. I just need to clarify, I have not been a prosecutor. I have been a practicing attorney for over 30 years, but I've been doing civil practice and victim rights litigation work for the past 30 years, and specifically as a victim rights lawyer the past 10.
So we'll get going here, and I know we like to call these the model practices, and
sorry.
Yeah.
Go ahead.
All right, you want to go to the next screen and we'll. Like I said, and Sasha introduced us. Thank you again, Sasha. And we do like to call these model practices. And I know that, just by way of introductions, like Sasha said, my work is a labor of love born out of tragedy, but, it's an important issue, victims' rights and capital cases as well. So Randy, I don't know if you wanted to add anything. This is our team here. There's a whole three of us, and as you can see, lots of experience. And we try and do the best we can as a nonprofit, providing free crime victims' rights, legal services in the criminal justice system, and advocacy. What that means is essentially helping victims assert and protect their rights in the criminal case. And Randy, God bless him, is able to go up and argue and litigate victims' rights issues, where if you didn't have an attorney, you can't necessarily do that. So, and
clearly the distinction when it comes to victim rights work is we have counsel and we represent victims as they work their way through the criminal justice system. And obviously the state prosecutes cases. Sometimes those issues come into conflict, and when they do, we assert the rights on behalf of the victims. And we're hoping at this point to talk about real life implications, and Dan's going to talk through some issues and suggestions in capital litigation work.
And just by way of background, I'll say, my brother's case was a capital case, murdered in a random act of violence, married, 40 years old, 2 kids, educated, and it was a capital case for 2 years till he pled to first-degree murder. I've worked, like Randy, on many capital cases. I've, in my capacity at the Attorney General and at the Governor's office, witnessed 2 executions with the victims' families. So I think both Randy and I have extensive background in these cases.
And I think the only other thing I'd like to add is some of the objectives that Dan's going to talk about, victim-centric issues, and I'm going to try and bring into this discussion perhaps some issues that prosecutors may see, and some professional responsibility or ethical considerations that come up, particularly in the context of capital litigation work.
And these are the objectives, hopefully give you an overview of victims' rights and ethical considerations in capital punishment cases, strategies for ethically preserving and protecting victims' rights during the prosecution process, and practical best practice suggestions for prosecutors and criminal justice professionals working with crime victims in capital case.
If anytime any questions arise, I think there's a chat box that you can type in a question, and if it's germane to a particular slide, we'll try and get to it right away if it makes sense. Otherwise, at the end of the presentation, we'll also have sufficient time, hopefully, for questions and answers.
No victims' rights overview. I'm sure as prosecutors, you're aware of this, but they attach on the indictment. If the death penalty may apply, meet with the family promptly to discuss. And some of these may seem sort of obvious, but it's not always the case. And trying to just sit down and meet survivors where they're at, length, and explaining, the length of time to impose the actual sentence, the different procedural differences, the guilt phase, the aggravation, the penalty trial phases, all the things that come into a capital case that don't apply maybe to a non-capital case, post-judgment direct appeals, collateral appeals, the victim, survivor, I use that term interchangeably, what their views on capital punishment. And, at the end of the day, it may not change the decision, but certainly it should be something that's considered. Differences in the allocation at sentencing, impact statements from survivors about deceased's characteristics and impact on the family, but not punishment. I guess it's been ruled it's not cruel and unusual punishment for a victim to perhaps say, they want life or death at the sentencing in a capital case. And so, we instruct survivors and victims not to, necessarily go down that road. Briefly, there was a case here out of Arizona, Dwayne Lynn, a career DPS pilot, Department of Public Safety, law enforcement, retired to a retirement community, and somebody came in at a homeowners association meeting. He was disgruntled and killed several people, including Dwayne's wife, who died in his arms, and it was a capital case, Richard Gassell. And ultimately, Dwayne, because of his age in his mid-70s, didn't want the death penalty and wanted to argue for life. So his family didn't have to go through the years of appeals. And of course, he wasn't allowed to say that, even though he was asking for the lesser, if you will. So
just adding a couple of things. In 1990, voters in the state of Arizona passed the Victim Bill of Rights, and it enshrined in the Arizona Constitution a series of constitutional protections and safeguards for victims of crime. Some of the relevant characteristics that I think Dan was touching on a little bit is that victims have the right to be heard on any issue involving sentencing, and what they say about punishment varies about punishment, whether it's a capital case or not. There's some case law that suggests a victim does not have the right to talk about punishment if it's a capital case, but if it's not a capital case, they certainly have the right to give a statement about what punishment they would like to see imposed. That's in our jurisdiction. They also have the right to confer with prosecutors over what punishment or plea agreements they believe are appropriate. And sometimes conflicts exist, and I'm going to touch on these issues, and maybe we can talk about it in more detail later. The conflicts might be different family members wanting to impose the death penalty and other family members not. How do prosecutors handle those types of situations? Under those circumstances, do victims ever have veto rights over prospective plea offers? Should they, under certain circumstances? Those are topics that I'd like to ask some questions about those who are participating now. What would you do under a certain set of hypothetical circumstances? But I'd like to go through some of these slides first and then follow up later if that's workable for everyone. Hopefully we'll have time at the end, because I would like to get some feedback from everyone.
So here's model practices, pre-trial and trial, create a clear record of all interactions to ensure rights are protected and documented appropriately. Last thing, obviously, anybody wants is it coming back or reversed or remanded and on appeal. So the better the record, the better the case. Be upfront about likely delay, appeals, the potential outcome, of a death penalty case. I think that's so important in working with survivors and victims. They just, may not necessarily understand, but the more it can be explained that this is going to be a long process, I think is the better. Explain the many intricacies of the case in a way that is accessible and understandable for victims and survivors. Again, good bedside manner, meeting survivors and victims where they're at. Pre-trial hearing to present aggravating factor, evidence in support of capital punishment. Here in Arizona, we have what's called the Cronus hearing, and where the state has to prove the allegations of death penalty. And, the defendant may request a probable cause hearing to support the aggravating circumstances, and just letting survivors and victims know we do this in every case, but explaining, you may see or hear testimony and pictures, crime scene, autopsy, whatever the case may be, and to prepare them for that up front. And the trial, the three phases: liability, aggravation, and punishment. Randy?
And I think I started by talking about victims' rights to be heard and rights to confer with the prosecutor. In our jurisdiction in Arizona and in several other jurisdictions that have adopted, I believe it's called Marcy's Law, and even with the Client Victim Rights Act, the federal act that provides statutory protections for federal crime victims. Victims have this right to give input to prosecutors, but prosecutors' obligations are to seek justice. And they have a separate obligation to seek justice and not merely a conviction. And the concern that comes into play potentially is to make sure that prosecutors do not serve two masters, meaning representing the interests of the state to seek justice, not just finding a conviction on the one hand, and at the same time conferring with victims and ensuring that victims have their constitutional rights referenced and protected, and the right to be heard, the right to confer with prosecutors. Those are situations that create potential for ethical challenges that prosecutors have, and that we certainly respect and see in the course of our practice.
Yeah, and I'll just add in, sometimes we do run into where, the prosecutor, like Randy said, represents the state, not the victim, and they're doing what's in the best interest of the community, which may be, hey, we're going to plead this from first degree death penalty to second degree. And so being able to explain those to victims, obviously before they get to court, before they hear that in a courtroom, and hopefully explaining the reasons. Some survivors may not support the death penalty. It should be treated with respect and dignity. There's an organization, I believe they're out of New Hampshire, Murder Victims for Reconciliation. They're not in support of the death penalty, but they're survivors and victims of death penalty cases. And, they talk about their experiences being treated differently because, as it says, differences among family members or, you're against the death penalty, so the prosecutors may not necessarily engage them. I'm talking generally. Explain the appellate process and the likelihood of decades of litigation, providing ongoing support throughout the entire process. Critical that victims, and here in Arizona, our Attorney General handles the appeals on death penalty cases typically. And so they've got advocates and prosecutors and appellate attorneys that work with the victims throughout the process. And if they want to see the opening brief, the responding brief, go to the oral arguments, obviously they can't be heard, but it's their right to be involved and included. And also, it's important ethically to maintain a professional distance from survivors, recognizing that you are not victims' attorney and that your role as prosecutor is focusing on upholding the law and seeking justice.
There are some Arizona cases that talk about how there's a potential to cross the line and engage in prosecutorial misconduct. You don't want to do that, obviously. And so that means do not overstep the line. That's, I think, why the last bullet point, maintaining a professional distance from survivors, is so important. Suggest a case in Arizona. It's called State versus Hughes. It's a 1998 case from Arizona, 193 Arizona 72, 969 Pacific 2nd, 1184. That case talks about the obligation to seek justice, not merely a conviction that I was referring to earlier. And a prosecutor's role is a minister of justice. And under those circumstances, it's possible, and we certainly see that, and we respect, as victim rights attorneys, we certainly respect the fact that our client's interests might not always be aligned with the interests of the state when it comes to discussing a particular plea offer or advancing a particular position with respect to either punishment or even issues in terms of restitution following conviction in a case.
Yeah, and I was going to add in here in Arizona, victims have a right at a plea offering. We just recently have this. It's probably the exception rather than the rule, but they have the right to be heard. And at a plea deal that was being pled from, I think, second down to manslaughter, the judge said, I can't accept this plea in good conscience, and state go back and redo it. So it wasn't a capital case, but that can be done.
Well, and if I may add just a
Yeah.
couple of thoughts. When the state believes it's appropriate as a minister of justice, and I think that's the case law under the Hughes case that I was just suggesting that it could be helpful to look at. If the state believes a plea offer is appropriate, if the victims oppose that plea, the victims have two rights. One is the right to confer with the prosecutors and say, hey, we don't think this plea is appropriate. And the state does not give, and appropriately does not give the victims veto power, but they certainly should hear the victims and their positions. And if it appears appropriate, they can reconsider a particular plea offer. On the other hand, if they don't believe it, then they shouldn't give veto power to, under these circumstances, to a victim if it appears that a plea is appropriate. And a victim nevertheless has the right at a change of plea hearing in our jurisdiction to be heard in open court and oppose a plea. So the hypothetical example would be a victim opposing a plea agreement that would take a case and move it from second-degree murder down to manslaughter for several evidentiary reasons. If the state believes that's appropriate, they present it. Victims have the right to oppose it in open court after conferring with the prosecutor, and let the judge decide whether to accept or reject the plea. In the hypothetical example, it would be the judge that rejected the plea, and then the state would have to go back to the drawing board and either adjust the plea or they take the case to trial. Under those circumstances, that is a hypothetical practice that works, that balances all ethical considerations that the prosecutor on the one hand has, and on the other hand, the ethical issues can be sorted out by the trial court when a victim exercises their right to be heard to oppose a plea. A circumstance that's not necessarily ethically permissible would be a situation where the prosecutor says, we will give you veto power and we will not present a plea. I'm a victim attorney, and I think that I still believe it's appropriate to explain that's not necessarily an effective way for a state to present its obligation as a truth finder, a seeker of justice, and a protector of justice under the circumstances. The state cannot serve two masters under the circumstances. On the one hand, serving the state, on the other hand, serving victims' interests. So that's the ethical issues that could come into play.
And we just talked about this, ensure the family's consulted and they know about any potential plea deal, realistic expectations about the return of victims' property. We run into this. You may never get it back in a capital case where it goes on appeal till basically the execution. But we've been able to get victims' properties back on request of the victim after consultation with the prosecuting attorney and law enforcement. They shall return, as the statute said, as soon as possible. And sometimes we've had to go and ask for a court order, I think, to have the information or property released, prepare victim survivors for trial, including testify, limits on testimony in the aggravation phase, and desire to leave the courtroom during sensitive testimony and evidence. We do a lot of trial prep with our clients if they're going to be testifying, and also if they're just going to be in the courtroom, which here in Arizona, victims have a right, even if they're going to be called as a witness, they have a right to sit in the courtroom and not be excluded and sit on a hard bench in the hallway. But just like the defendant who may testify, they have, or the case agent, they have a right to be there. And that's important. But we do try and work with folks, and we've told them, some people want to go and sit in another room during crime scene photos or the medical examiner's testimony. Some want to sit through it, but we've been able to have them sit in a victim's room where we cover the TV and they can't see it. Some people want to do that, and then they come back in and treat the victim's family with empathy, compassion, and respect throughout the entire process, recognizing how complex and emotional the nature of their experience. And I think that's so important because the work of capital prosecutors is not easy, obviously, and it's in stating the obvious, it's not just another case for the survivors or the victim's family. And so the more that you're able to relate with the survivor's family, I think it just makes a better experience, if you will.
And the only other thing I'd add is it's really not a violation of ethical responsibilities or strategic issues that prosecutors have to try a case to talk with family members before a particular day of trial, just so that they can understand and know what to expect, and whether there's particular gruesome photographs, for example, or an autopsy set of autopsy photos, or a medical examiner that will be testifying. It's clearly part of that process that I think in Arizona is still referred as the right to confer with victims, not the right to veto or control the prosecution, but it's really important so that victims know what to expect and can make their own decisions about whether to sit in the courtroom and see these gruesome photographs, if it's a tragic crime. Those issues, I think, are helpful to know in advance that it's okay to talk about what witnesses and evidence will come up during a day of trial, just to help victims prepare. And that's what we try and do in our position as victim counsel or victim advocate, just to help in advance so that victims can prepare themselves for a trial when a case is going to trial.
Yeah, we like to say, survivors or victims just want a voice, not necessarily a veto. And I think that victims' rights allows them to have a voice and be involved and included. Model practices for post-conviction, as we know in capital cases, that's definitely a part of the criminal justice journey, if you will. Be aware of media inquiries and ensure that victims and survivors know their rights and options when speaking to the media. Family member communicates with the press, ensure they only discuss their loved one, not case specifics. Comments to the media could affect appeals, and we always tell survivors, or talk to the prosecutor, talk to law enforcement, don't speak out before you get the okay from them. And some people like that, some people don't, but I think, and as the slide says, talk about who they are and don't compromise the case in the media, and be talking about, case specific things that could be used against the prosecution. If victims opt in or request appeal information, promptly provide them with copies of the relevant legal documents, as we said, opening, answering, or reply briefs and other motions. And also notice, like I said before, if there is an oral argument, oftentimes victims want to go, or survivors be there, and ensure that victims, survivors understand that any appeal is defense right and does not necessarily mean it has any merit, and set realistic expectations. And that's important because I know when I worked at the Attorney General's office, victims would call and they were upset, after reading, an opening brief, and it's like, this isn't true. And it's just explaining that, anybody can file appeal. It doesn't mean it have merit, and to meet face to face with the appellate attorney, or at a minimum on the phone. And as I said, allow them to attend oral arguments, keep their contact information up to date with the prosecutor and correction staff. It's a long journey to an execution. People move, and Victims can go to the execution. They're typically invited by the director, for lack of a better word, invite, but and arrange a meeting between the family, the advocate, and capital defense attorney to ensure the family's needs are met and they have access to the resources and support. I don't know if, do we mean a capital prosecuting attorney there, not a defense attorney? I think we might add a little typo, but in any case. And then the executions, I'd like to see a statute some point here in Arizona where the director of corrections has to invite the victims. Usually it's not an issue. I haven't seen it, but there is no statutory right to necessarily extend. But like I said, I haven't seen that be an issue, and our corrections department has a good victim services and they work with folks. And when I attended 2 executions, and I believe they still do this, the family is the last witness in attendance, and then they're the first ones to leave. And so that way, they're not standing there. They don't have to see the defendant's family, or they're really treated, dignified, if you will. And they meet with the Department of Corrections director ahead of time in a separate room. There might be some water or light refreshments, just because people are going into, witness an execution. And I don't mean, refreshments as in a celebratory way, but I think it's just the way they offer some cookies or something. And prosecutor attendance is important. Randy, anything that?
No, I think I'm going to wait till the end.
All right. Key is to ensure that victims and their families are treated with respect, sensitivity, dignity throughout the execution process, and the rights of the victims of the crime are upheld through the entire process. One thing we didn't really touch on, but I'll just briefly touch on, is contact by a defense attorney to a victim in a capital case. We have a case that's on appeal at the Court of Appeals in the Ninth Circuit, because we have a statute that says the defense attorneys must go through the prosecutor's office before they make contact. And there was a district court judge here, Logan, that ruled on a case that said basically it was a violation of, and correct me if I'm wrong, Randy, First Amendment rights, and that the defense should be able to at least make contact with the victim, maybe not interview them, but make contact and ask if they want an interview. And so that's highly contested. And we're hoping, because it's been the law here since 1991 or 90 and never been challenged. And I remember a capital case where the defense attorney, before the commutation hearing, one of his investigators the night before showed up at the widow's home and said, I'm a representative of the state and I'm here to ask you some questions. And it wasn't the most ethical or proper thing to do. And of course she was distraught, but anyways, I diverted.
These are general discussion topics, and we clearly can't go over everything in intricate detail in an hour webinar, but I do want to raise maybe some different scenarios that come up that could create some ethical questions. And I'm hopeful that if I could get some feedback by typing in the chat box, I'd like to ask you what you and your jurisdiction would do, and maybe talk about what we do in Arizona as after I get some feedback from everyone about let me give you this factual situation. You have a case that would be considered for capital punishment, but you have an unwilling witness next of kin victim. Under the circumstances, the victim next of kin witnessed a murder that could potentially be eligible for capital punishment, but does not want to testify at all in support of the prosecution. Can I get feedback from everybody about what you would do under those circumstances by just typing in to the chat box briefly? what thoughts, if you need more information. This is a hypothetical situation, and I'm just curious what kind of feedback I can get from other webinar participants, and then I'll tell you some Arizona details. Let's see what we have here. No, I don't see any.
See anything yet?
Okay, that's quite all right. What I'm going to basically talk about is, remember, the victims in Arizona and other Marsy's Law jurisdiction states and under the CDRA, victims have the right to be treated with fairness, the constitutional due process right to be treated with fairness, dignity, and respect throughout the criminal justice system and the prosecution. Victims also have the right to confer and the right to be heard. If they choose not to want to participate in the criminal justice prosecution, there are some issues that get triggered. How is it that they can be treated with fairness, dignity, and respect on the one hand, and on the other hand, be compelled to testify in support of a particular prosecution? Arizona law, in particular, it's a case. I'll just give the citation: SA versus Superior Court, 171 Arizona 529, 831 Pacific 2nd 1297. It's a case from Arizona appellate courts from 1992. Does suggest that a victim can be compelled to testify in a trial. But if the victim is, on the one hand, going to be a reluctant witness, I think it best to treat that situation as sensitively as possible. The fairness, dignity, and respect component of the constitutional obligations to victims certainly comes into play if it looks as though the prosecution will serve a purpose of helping society in Arizona or finding justice in Arizona. This is a situation where there's competing constitutional implications, competing goals. The state's goal of prosecuting and seeking justice and finding truth on the one hand, versus the state-based constitutional right of the victim to be treated with fairness, dignity, and respect. So you can certainly compel a victim to testify in the underlying prosecution. Now, at sentencing or restitution hearings, a victim cannot necessarily be compelled. There's different case law under those scenarios. But when you have an unwilling victim, that's a very difficult and challenging ethical dilemma facing prosecutors. At the end of the day, the prosecutor certainly has a right to compel a victim to testify. But on the other hand, it would be as helpful as possible to do that as sensitively as you can, and only do it if it serves a useful prosecution purpose.
I was just going to throw in, I mean, there are examples where victims have been subpoenaed and they didn't show, or they could be, I guess, theoretically put in jail, for ignoring the subpoena. But I think it would just create a hostile witness anyways. But I understand the balancing act that prosecutors in the state must have to prove the case.
And it's certainly the potential, if a victim is subpoenaed, there is certainly potential to seek punishment or compliance with the subpoena if the victim doesn't show. If it's a subsequent or post-trial proceeding, the punishment, you can't throw a victim in jail, or you can't seek a remedy other than not necessarily pursue a claim for restitution, for example. You can't seek to prosecute a victim if they don't show up for a post-trial restitution hearing. There's case law on that point. But the underlying trial, if the state has a reluctant or unwilling victim witness, they certainly can be compelled to attend and testify. Treat that with kid gloves if at all possible. I think we talked about the other type of scenario where there's interest in the state in a particular to advance a particular plea offer, yet victims oppose that plea offer. That is another challenging set of circumstances, and rather than giving the victim a veto on a plea, it's best to either get on the same page, or if you can't, if the victim continues to oppose a particular plea, then the remedy, or not the remedy, the approach and the suggested practice would be, if the state believes it's proper in their truth-seeking function and their function to only serve the state's interests and not two masters, present the plea to the defense. If the defense agrees, present it to the court at a change of plea hearing and give the victim the opportunity and notice of that particular change of plea hearing, and then the opportunity to oppose it and leave the decision whether to accept or reject the plea to the court. If the court rejects the plea, then you go back to the drawing board, as we mentioned earlier. I guess the worst case scenario is if the state does not believe trial is appropriate. I guess the worst case scenario would be making a decision not to pursue prosecution. But we certainly believe victim input into the process should not prevent the state from moving forward and advancing a plea it believes is appropriate. The other scenario that I think is important, particularly with capital litigation cases, is to really understand and be sensitive to victim families, but do not become overly closely associated with them out of a fear that you might be becoming a victim avenger when it comes to the prosecution of a capital case. It's easy to do, and we see the potential where a prosecutor's zealous and wants to avenge the particular conduct that occurred that has caused our clients and family members and next of kin to have to deal with such a tragic loss. Nobody in our none of our clients have asked to be forced into the criminal justice system, and the prosecutor's job and responsibility that we see all the time as professionals is to be as sensitive to the families of crime as possible on the one hand, without going too far. And that's hard to balance sometimes, because sometimes the conduct that we see as victim attorneys and victim advocates is just tragic. It's horrible. And balancing the state's interest in prosecuting that criminal for the offense with the careful need to disclose all potential Brady material and all defense information that's necessary for mitigation or to consider mitigation. It's hard. And as victim attorneys and victim advocates, we clearly serve what we believe is an important and vital function on behalf of the victim to advance victim interests and rights. And the defense obviously does that on behalf of the defendant. And the state's interest is hopefully not in a place where there's a situation where victims also are represented by the state, because then it, I think, invites either a retrial down the road or prosecutorial misconduct allegations, and we never want to see a case go to retrial on a capital litigation matter. It's hard enough to sit through a trial in the first place on capital case. We don't want to see it happen more than once. So,
and I will just say it does, Randy's right, and it cuts both ways. As an example, in my brother's murder case, 2 years into it, it was a death penalty case. And on our second prosecutor, he asked if he could meet with me and my dad for a cup of coffee, and we did. And he said, I can't anymore prosecute homicide or death penalty cases. I ethically and morally now oppose the death penalty. And so I'll no longer be your prosecutor. And as frustrating as that was to us, I was really glad, and my parents were, my sister-in-law, that he recognized that and that he wouldn't ethically or morally go argue something he's opposed to. And so we got another prosecutor.
In deciding whether or not to impose capital punishment, I think it's important to get victim input, though, and family members and next of kin input, I think, is a really important piece of information that helps the state make a determination independently, of course, but in determination nonetheless about whether to seek capital punishment. It's important to know what input family members want to give into that process. And it's important before making a final decision on imposing capital punishment to get that input from family members if they choose to express input. And some family members don't want to see the death penalty. So another set of potential challenges are whether one set of next of kin opposes the death penalty, and then another set wants to see the death penalty, and getting input from all family members and all next of kin who are considered victims is an important part of the prosecution process, at least since the Arizona days in 1990, when voters made a decision that victim rights are going to be constitutionally enshrined, and so that victims under circumstances are not treated as a piece of evidence, that they're actually seen and heard, not just seen in connection with the prosecution of a case. So it's important to get feedback, and then under the circumstances, at least as we represent victims, if there are differences between the family member's position on capital punishment, at least our organization would not be able to represent multiple victims under that circumstance. We would represent one set of family members who support capital punishment or don't support capital punishment, but we would likely not represent both under the circumstances. When it comes to capital punishment, it may create, at least from a victim attorney perspective, an issue to think about with how we can advance the views of one set of next of kin without taking away from the other set of next of kin family members. And we would potentially be in a situation where we would have to have multiple counsel representing family members.
I wanted to touch briefly, if we got enough time. I think we do. And, we have an expertise on restitution, and certainly restitution plays a role in capital cases. And, we can give some examples, but oftentimes it's not thought of because it's like, well, they're going to death row or serving life. But for many survivors or victims, it is meaningful to have something ordered. And we had a case, a capital death penalty case, where the defendant murdered his wife in front of his kids, and lo and behold, he stopped paying his mortgage, and the house got foreclosed on. But there were excess proceeds that would have gone to the defendant and his attorney or whoever, and Randy was successfully able to argue and hold that money in abeyance until he was convicted. And so I just wanted to throw that out because we had a little bit of extra time. But same with future lost earnings, where, the guy's going to prison, but maybe it's one less bag of chips or whatever, the guy or woman, whoever. And the thought is, hey, what would have the victim earned over their lifetime? And we extrapolate that out, bring in a economist to testify as an expert. And so I think there are things with restitution that, can be somewhat meaningful. Every survivor victim's different. Some may not want it, but certainly we've been successful in it.
Under certain circumstances in a capital case, if, for example, the police department has seized certain evidence that might have value, watches, vehicles, other property that might have value, there is a tool in our jurisdiction that would allow post-conviction, develop the amount of economic loss facing family members, and then ask the court for an order partially executing on the, it's a writ of partial execution to seek a return of some of the potential valuable property held by police in order to monetize whatever that amount is that might have value. We've been successful in seeking recovery of a watch, for example, Rolex watches and vehicles. Dan mentioned a home that was foreclosed on. We had what's called a pre-conviction restitution lien to preserve excess proceeds for purposes of restitution at later time after prosecution concluded. Bonds that have been potentially posted to secure release, although typically with capital litigation that isn't necessarily going to happen. More often than not in capital litigation, it has to do with property that would be helpful to see what is in possession of police and then try and use statutory tools to establish restitution and then recover property and sell it for purposes of satisfying all or partial satisfaction of the economic loss. Restitution is what we consider the last frontier when it comes to victim rights. There's some misconceptions that we think started way back in the 1990s, late 1990s, beginning with the U.S. Supreme Court case, United States versus Lagos. The holding in that case basically said, and I'm inferring the holding, for the most part, we don't care about restitution because 90% of restitution is uncollectible. Well, even in capital litigation cases and non-capital cases alike, we think that's kind of a self-fulfilling prophecy. By saying that, restitution becomes uncollectible. And instead, our experiences as advocates and attorneys in our organization is that if you emphasize it, if you emphasize the need to establish and collect restitution, your collection rates are going to be much higher. And it's not going to be 90% that's uncollectible. Certainly, there's a lot that is uncollectible, but prioritize it and you'll see a better collection rate. And that's even true in capital litigation cases, whether it's evidence in the police department, whether it's property tools, they give victims at least the ability, if they want to. Family members may or may not want to pursue and establish restitution for the economic losses and then make efforts to collect on it.
And here in Arizona, I mean, the statute says the director can take anywhere from 20 to 50% of what's deposited into their inmate trust account or account. So, even if they're not working, but a family member sends $100 or another gang member, whatever, $20 will go to the victim. And again, sometimes it's symbolic. Sometimes, the survivor wants their money back. The other thing I want to just briefly bring up.
I just want to give you both a time warning. We're at 7 minutes to the top of the hour.
Okay, thank you. Just real quick, because it's one of the things I think that does play, although we don't take a position on it, is politics and the death penalty. And sometimes, as prosecutors, it may not be your role to explain the politics, but that goes into sometimes the long delays or maybe somebody gets elected and decides we're going to put a moratorium or we're not, or the attorney general or whatever. There's lots of different dynamics that sometimes, even if it's a conviction, could be delayed because someone doesn't believe in it.
We've talked a lot about victim rights and we've tried to do a very generic overview of the rights, at least as they're applied in Arizona. They apply with equal vigor, I think, to other jurisdictions that particularly have Marsy's Law, or if you look at the Federal Crime Victim Rights Act. One of the things I was hoping to kind of impress upon everybody is we value and respect the work that prosecutors do across the country. And we, generally speaking, as victim attorney or victim advocates, really appreciate having the opportunity to work with prosecutors to give input and to ensure that the needs of our clients are at least shared with you so that you can do your jobs effectively. We never want to act as adjunct prosecutor, but we do appreciate the opportunity to give input as a victim rights lawyer or advocate into the process of prosecuting defendants. And we respect the work that all of you do and really appreciate the efforts that you make to find justice and really pursue state's interests in justice, and appreciate having had the opportunity to talk to you today.
And Randy, we did have a question in the chat room too.
Yeah. So thank you both for presenting today. I would just like to open it up to our audience. If you all have any questions that you would like to put to our presenters, feel free to use the Q&A box, or you can just throw it into the chat and we'll read it out. But we do have one question here. Do you have templates for pre-conviction restitution? Is there case law and or statutes supporting the motions?
And if this message, it's from
And
Tanya, I believe.
Yeah.
To answer your question, yes. I would suggest that, at least in our jurisdiction in Arizona, we look at a pre-conviction restitution lien almost the same way as we would look at an injunction or a temporary restraining order. Under the circumstances, if you meet the elements that would support a temporary restraining order or an injunction in a civil case, you have similar elements with respect to a pre-conviction restitution lien. It's a fairly new process in Arizona under, I believe it's ARS 13806, that allows for the use of a pre-conviction restitution lien. Our office, the Arizona Crime Victim Rights Law Group, does that work, and we typically have a form that we use. We have, we have to file a motion and support it with a proposed restitution lien. And I believe that you're suggesting yes, your answer, your follow-up question, that like in a divorce or restraining order on assets, yes, I think you need to show the same type of evidentiary standard, but obviously in a criminal case, you need to show the likelihood of success. You need to show perhaps a fear that somebody might be secreting assets. You need to show the likelihood that the victims will have economic losses subject to need for a restitution award in the future. And if you can show those types of elements, at least in our jurisdiction, 13806, I believe, is the statute that says we are allowed to file a request for a pre-conviction restitution lien. We treat it, there's no case law on this issue, so we treat it as though it's like a preliminary injunction request or a temporary restraining order. The statute is so new that there is little to no case law on it, but that's how we approach it. And we are very careful in the types of cases we suggest pursuing a pre-conviction restitution lien. I hope that answers your question, Tanya.
And I believe, correct me if I'm wrong, Randy, victims in Arizona can do it on their own if they
Yes.
to file a pre-conviction restitution lien. But
Okay, well, I'm not seeing any additional questions in the Q&A box right now, but I just wanted to say to you both, thank you so much for your time and for sharing your expertise with us today. And I know there will probably be more questions. So if anybody else wants to reach out to either of our presenters, you can email apaadmin@apainc.org and we will connect you to them. As well, this webinar is being recorded, and any materials that are associated with this, as well as a recording of the video, will be up publicly on APA's website, our YouTube channel, and our membership database within 3 to 5 business days. So keep an eye out for that. That concludes our webinar for today. Thank you so much, everyone, and have a great rest of your week.
thank you.
Thank you.